Good morning, everyone, and welcome to First Draft, where I talk with journalists about their important work and the stories behind them. I'm Susan Demas, the executive editor here at Lincoln Square. The Supreme Court has already come out this year with some consequential rulings, like striking down Trump's tariffs. Last week, justices heard arguments about the Trump administration's challenge to birthright citizenship, and other key rulings are expected soon. For more on that, we are turning to Mark Joseph Stern, who writes for Slate and is one of the foremost SCOTUS reporters in the country. He joins us to tell us everything that will be making his life miserable for the next few months. Thanks so much for being here.
Thank you. I will try my best to not be miserable in this moment, even though you are correct. The misery is coming and there is nothing I can do to stave it off.
I know that every time it is a day that opinions might be released, you probably are sitting there thinking, what's coming down the pike? What do I have to be prepared for? And historically, the court has often left its biggest rulings for like the last part of June, but there are so many cases that they're contemplating that the misery, so to speak, will be spread around. Am I wrong?
Well, it's hard to tell right now because the court has been issuing opinions at a pretty steady clip. We've gotten some big ones. We got the tariffs in February. We got the conversion therapy case just recently. And so it seems possible that some of the biggies could come down in May or earlier in June. On the other hand, it only takes one justice to clog up the process, right? For instance, with tariffs, it seems pretty likely that Justice Gorsuch dragged out the release of that opinion by writing a 46-page concurrence, taking issue with almost all of his colleagues on various points of disagreement. And so in some of these coming cases, like the voting rights case, there could be a liberal justice who decides, I need to write another dissent, and that takes an additional month. Like there's always something that could sort of force the court to wait beyond when it wants to release an opinion. And so I would not put money on big stuff coming down sooner. I would not be surprised if it does.
Before we get into some of the decisions that you've been reporting on and you're watching, I was wondering if we could just kind of put this moment in some historical context. We have a very conservative court. They've made extremely important decisions on presidential power, civil rights, and more. But can you talk with us about the dynamics on the court and how this court fits into history and might be a break with it?
Yeah, so it's certainly the most conservative court since the early New Deal days when the Supreme Court regularly struck down a lot of FDR's measures to try to end the Great Depression. And it's an interesting dynamic because even though there are 6 Republican-appointed conservative justices, they do have kind of different views and different approaches that can lead to fractures like we saw in the tariffs case. So I would say that Justices Alito and Thomas are just the most sort of MAGA justices, right? They are very, very political, super partisan, and almost always vote to support Trump's agenda. Thomas, a bit less so than Alito, but they're pretty much in the same boat these days. Unfortunately, I would say that lately, Justice Brett Kavanaugh has been kind of joining them in a lot of these high-profile cases. The tariffs case was proof that Kavanaugh has been drifting rightward for several years and seems to be very supportive of Trump's agenda from the bench. And then you have Justice Gorsuch, who is kind of a wild card. He can be political. He can be extraordinarily conservative on issues like voting rights and abortion, but then he can be sort of liberal in surprising ways on things like native rights, in recent cases, presidential power sometimes, in other cases, not so much. He's a wild card. It's hard to guess. And then you have Barrett and Roberts, who are sort of the moderates, like duo, who hold a lot of power in their hands these days because they're the deciders when a case comes down to them, and they can sort of steer the court to the right or toward the middle, and they can always join with the 3 liberals to try to reach like a compromise, or they can side with the other Republican appointees to, go big and issue a really major victory for the Republican Party. And more often than not, to be clear, they go big and issue major victories for the Republican Party. Like, I don't want the tariffs case to make people think that this is a moderate court or even a court that's regularly standing up to Trump. I mean, one of the issues that maybe we can discuss is the rise of these emergency decisions on the so-called shadow docket, where you see over and over again the 6 Republican appointed justices siding with Trump, often without an opinion, right? Sometimes issuing decisions late at night without explaining themselves, clearing the way for Trump to implement some extreme part of his agenda. And so we shouldn't lose sight of the fact that more often than not, the conservative majority is rowing in the same direction as Trump, but there are still some areas where they'll break from Trump, sometimes just to show him that they are independent and still have their own power they can sort of wield against him. And those are the areas where there's hope for Democrats in a decision that's not full MAGA.
Yeah, talk with us a little bit more about that shadow docket, because the use of it really seems to have exploded during Trump's second term.
Yeah, so for centuries, the Supreme Court operated in like the same way, right? They take up certain cases, they hold oral arguments, they have full briefing, they issue written opinions. We know how all the justices voted, they explain themselves. In the last 5 years or so, we have seen a kind of turbocharging of this alternate way of doing things that is often called the shadow docket, where the justices don't hold oral arguments. They don't have full briefing. They don't ever discuss a case at conference. Like, they don't sit down and sort of hash out their views. They just get a request, more often than not, from the Trump administration these days. And we don't know if it's by email or fax or text or whatever. They just say, here's how we're going to do this. And they do it. And they issue some kind of major order without, again, more often than not, explaining what they're doing, and allow for one party to prevail. And sometimes it's an absolutely huge win, and we don't even know why it happened because the court didn't explain. So much of Trump's immigration agenda has been greenlit over the shadow docket. The court has used the shadow docket to authorize ICE and CBP to engage in racial profiling when detaining suspected undocumented immigrants, to focus on people who appear to be Hispanic or who speak Spanish. The court has used the shadow docket to allow the Trump administration to deport immigrants to countries they've never stepped foot in, places like South Sudan and Uganda that are so dangerous that the government tells Americans not even to travel there. We're deporting people there right now because the Supreme Court allowed the government to do that. And the court allowed Trump to really kind of restructure the government by seizing power from Congress to do things like abolish the Department of Education, right? By firing hundreds or thousands of workers. These mass layoffs and so-called reductions in force that were never approved by Congress, that are done illegally. These efforts to withhold billions of dollars in spending that Congress appropriated. The Supreme Court has allowed all of that, and it's done so over the shadow docket without explaining why.
Mark, I was really struck by you using the term MAGA justices, because it was not so long ago that we kind of believed in this quaint idea that even though Supreme Court justices were appointed by presidents who were Democrats or Republicans, that their politics were kind of supposed to end when they put on the robe. You wouldn't see justices giving political speeches, for instance, like we have quite frequently from Samuel Alito in particular. Can you talk with us about how this change came about, and to the point that it's really not even something that we acknowledge? We just kind of take it for granted now.
Yeah. So, I mean, one sort of reference point I like to remind people of is that in Clinton v. Jones, in the 1997 case, the Supreme Court ruled against Bill Clinton and said he didn't have immunity from Paula Jones' litigation against him. He wound up having to testify, answer all of these questions, right? That was a unanimous decision. His own appointees sided against Bill Clinton in that case. The court across the board said that Bill Clinton as president had no immunity just because he happened to be the commander in chief. Fast forward to where we are today. It is unthinkable that the Supreme Court would ever issue a unanimous decision that directly rebuts the president of the United States' claims of power or immunity or authority, right? We know that there's always going to be probably 1, 2, 3, maybe even 4 votes in favor of Trump. We know that Sam Alito is going to defend Trump's policies and Trump himself. We know that Clarence Thomas is going to concoct some dubious historical record to say why Trump gets to do whatever he wants. The tariffs case proved that Justice Kavanaugh, will just make some stuff up because he wants to rule for Trump. And to your earlier question, it folds back into this. This is a break from how the court has operated for many, many centuries. Like, Chief Justice John Marshall, the great Chief Justice, he regularly issued decisions that disappointed his allies in government because he felt that once he put on the robes, he had to be a neutral arbiter of justice. That sort of principle guided the court for years, and now it's gone. We just don't see it, especially among a bunch of the Republican appointed justices. And I mean, that's quite the boon for Trump, because most parties walk into the Supreme Court not knowing if they have anybody in their camp. Trump walks in knowing he's starting with 2 or 3 in his pocket, and it's not that much of a stretch to get to 4, 5, or 6. And I think that really degrades the court as an institution. It makes Americans wonder, understandably, why it gets to wield so much power when its members are unelected, why it gets to override the decisions of, say, Congress, right? And, the representatives of the American people, when it's really kind of acting like, in many cases, a fundamentally political apparatus that's just designed to help the party that put them in power in the first place.
And to your point, just last week, President Trump took the unprecedented step of going to oral arguments and sitting there during the birthright citizenship hearing. It seemed to be a not very subtle message to justices, especially those whom he had appointed, that he would like them to rule in a certain way. Is that a fair interpretation?
I absolutely think that's what was going on in that case. I think that Trump wanted to stare down the justices, and he specifically wanted to remind Gorsuch and Amy Coney Barrett, who voted against him in the tariffs case, that, they're only where they are because he put them there, and to make them feel that they should owe him some loyalty or some allegiance. Now, I don't think it worked. I actually think it was quite foolish, and it shows he misunderstands the dynamic at the court, because this is one of those few cases where I think that justices like Gorsuch and Barrett are going to buck the president. And I think that his presence, if anything, reminded them that they really do need to stand up to him, at least from time to time, to remind him that they get to overrule what the White House wants to do whenever they want, because otherwise the Supreme Court stops being, part of an independent branch of government, and it's just some outpost of the executive branch that rubber stamps everything the president does. The 6 conservatives mostly want Trump to be able to, pursue his agenda. They don't want to do so at the expense of their own authority.
Given the enormous power that the Supreme Court wields, and some of the extremely controversial decisions that they've made, from the Dobbs case in 2022 on abortion rights to the presidential immunity case in 2024 with now President Trump, there have been murmurs about court reform, whether it's term limits or expanding the court or sweeping ethics reforms. How much will really is there for those kinds of reforms, or is this really what we're stuck with, and we need to work within these confines?
Well, I don't think that we are stuck with anything. The Constitution allows Congress to set the size of the court. Congress has changed the size of the court many times in the past. Congress actually changed the size of the court to prevent President Andrew Johnson, from appointing justices after he succeeded Lincoln, and then expanded the court again to allow Ulysses S. Grant to nominate justices. This has been political football for a long time. We saw this when Republicans blocked Obama from appointing Merrick Garland to the court and keeping a vacancy open for more than a year. Clearly, like, the Republican Party is happy to play hardball over this. I don't think Democrats are there yet. We saw under Biden's presidency some support for court reform. It ended up sort of fizzling in part because Biden wouldn't really come out and robustly endorse anything that would have a meaningful impact on the court's jurisprudence. I think things would have to get worse for the Democratic Party to seriously engage with the possibility of reforms, whether it's imposing term limits, including on the current justices, expanding the size of the court, an ethics code that can be enforced, right, that has real teeth, that forces justices like Clarence Thomas to stop accepting gifts from billionaires and going on mega yacht vacations. I think all of that stuff is only going to be politically viable when the Supreme Court's popularity has truly tanked and hit something like rock bottom, and when Democrats feel that it's irredeemable. But this is the genius of someone like Chief Justice Roberts, right? He knows that the court is in peril if the Democratic Party ever believes it's irredeemable. And so he is always on the lookout, in my view, for these cases where he can try to show that the court still exercises some independence. That was the tariffs case. That's probably going to be the birthright citizenship case. These should have been really easy cases. Like, it's kind of an embarrassment they even got to the Supreme Court. The first sentence of the 14th Amendment says that birthright citizenship is a constitutional guarantee. Like, we shouldn't overly praise the Chief Justice for being able to read the words of the Constitution, but that's sort of where we are. And I do think he will get a lot of really good press for that decision, just as he did for the tariffs decision. And I think that that will stave off the kind of serious possibility of court reform by the Democratic Party. And it's only when the court is just so fully in the tank for Trump and for the Republican Party that zero kind of, defensible independent rulings are issued. Only at that point will Democrats really be able to muster the votes and the courage to do some real reform here.
If you're just tuning in, I'm Susan Demas, the executive editor at Lincoln Square, and this is First Draft. I'm here with Mark Joseph Stern. He is a senior legal writer at Slate, and we are breaking down all that is going on with the Supreme Court. Mark, I wanted to talk with you about the decision last week on conversion therapy. And there's been a lot written about this. There seems to be a bit of confusion about the decision, but the upshot is that the Supreme Court did make it difficult for states to ban conversion therapy that essentially, aims to stop people from being gay or trans. My state of Michigan is one of those that, has a law banning this practice. I know that there are many medical societies that have found that this is an extremely harmful practice, but the Supreme Court issued a ruling that that essentially did make it easier to keep this kind of therapy on the books. Can you break down the complexity? And also, this was an 8-1 decision that I think surprised a lot of people.
Yeah, so this case really kind of undermines laws in about half the states, including Michigan. This was out of Colorado. A bunch of purple states have these laws as well, that prohibit licensed counselors from trying to convert LGBTQ youth. So 2 key points. It only applies to licensed therapists who are accepting money for services, and it only applies to minors, right? A gay adult is still free, even under these laws, to go to a counselor and say, make me straight, and the counselor can try. These were enacted in response to pretty extensive evidence, body of scientific literature showing, as you said, Susan, that it doesn't work to try to convert someone from being gay or transgender, that it's actually harmful and increases risk of suicide and depression. And so these states banned conversion therapy in all their forms, including what the court calls talk therapy. So a counselor just sitting across from someone saying, stop being gay, right? That's different from some of the most extreme versions of this that we've seen, like electroshock therapy for gay children, which is something that's been practiced, but it's still extraordinarily harmful and abusive. But the Supreme Court said in this decision that it was protected speech under the First Amendment, and said that any law that restricts this kind of speech is presumptively unconstitutional. Didn't quite strike down the Colorado law, but more or less said that it could not be enforced against, again, talk therapists. And what that means is that every other state that has a law like this on the books isn't going to be able to enforce it against therapists who try to convert LGBTQ minors, even if there's proof that they're, engaged in quackery, which they are, that they're hurting children, that they are, violating the standards of care. Every major medical association in the country opposes this stuff. But the Supreme Court said it's still protected expression. So it's just too bad for the kids who are hurt. My view on the 8-1 ruling is that Justice Kagan, joined by Justice Sotomayor, were looking to try to maybe moderate the majority decision, and they might have succeeded. So they didn't, the majority didn't, as I said, go all the way towards striking down the entire law. The majority said that there were parts of the law that couldn't be enforced in certain ways. That is, in my view, still quite bad. I mean, it's going to lead to abuse of minors, but it doesn't take the extreme step that some religious groups were hoping for, of just destroying these laws altogether and rendering them unenforceable in any way. So, conversion therapy that involves so-called aversive techniques, like some kids are made to wear a rubber band around their wrist and snap it every time they have a gay thought. That stuff is not protected, and laws against that stuff are still on the books. And I think that Justice Kagan and Justice Sotomayor tried to, in this concurrence, steer states toward another way of regulating conversion therapy that wouldn't necessarily run afoul of the First Amendment in the Supreme Court's view, which is to maybe try to say, we aren't banning conversion therapy itself, but we're saying that practices proven to harm minors cannot be done by licensed therapists. Practices that are dangerous and discredited by these medical associations cannot be performed by therapists. And they suggested that those kind of broader laws might survive constitutional scrutiny. Look, I think that they were trying to show the conservatives that they're just willing to compromise, basically. I think that it's going to hopefully pay off in other cases. Like, they're trying to show Barrett, Roberts, Gorsuch, like, we're not just going to vote liberal every single time. We're willing to come to the table and try to hash out some agreement, some compromise with you. And, that's strategic. Who knows if it'll work? I don't think Justice Ketanji Brown Jackson thought it would work. She dissented very vigorously. But I think that Sotomayor and Kagan have been there for a while. They're playing the long game and trying to show their conservative colleagues that they're reasonable and hoping it'll pay off down the road.
In 2015, another iteration of the court, still a conservative one, did rule in favor of same-sex marriage. And there's definitely been a lot of interest from conservative groups to relitigate this decision, much in the same way that Roe v. Wade was relitigated, the exact same case with Dobbs, with a different court, formation of a court. Does this decision give us any insight into whether or not the issue of same-sex marriage may be determined again once by this court, or is this really a different matter?
So in a kind of perverse way, I think this decision shows us why the Supreme Court isn't going after marriage equality, because what the conservative majority wants to do, in my view, is not go straight at same-sex marriage, because same-sex marriage is very popular. It polls, supermajority support, overwhelming endorsement by most Americans. It's not something that the conservatives want to unsettle, at least most of them. What they want to do instead is undermine LGBTQ equality by using the First Amendment as a sword. And the conversion therapy case is a perfect example of that, right? They're not overturning marriage equality, but they are telling states that they can't protect LGBTQ minors from a pernicious kind of abuse dressed up in the guise of medical treatment. Just a few years ago, the same court ruled 6-3 that states couldn't prohibit a web designer from discriminating against same-sex couples because she had a free speech rights to design or not design websites as she chose, and that she couldn't be compelled to design one for gay people. We've seen similar decisions involving same-sex adoption. We'll probably see more down the road involving these like photographers and bakers, right, who don't want to serve gay people. And I think that the court is content sort of going after gay equality that way rather than going straight at the biggest target. But I think for trans rights, this court is extraordinarily hostile. We saw it last term when the court upheld bans on gender-affirming care for minors. We see it here where the court says that states can actually not protect trans minors from abusive attempts to convert them. And I think we'll see it very soon in a case involving transgender athletes this term, when the court will very likely hold that states can ban transgender women and girls from participating in school sports. So there's a divergence here where you have gay people still clinging to those fundamental protections, but sort of losing others around the margins. And then you have trans people under full assault by the Supreme Court majority.
A couple more cases that I'm sure you are intensely following. The Calais case involving the Voting Rights Act. And then, of course, there were just arguments on mail-in voting. Can you break down those cases for us and what you're looking for from the court on both of those?
So the mail voting case I'll start with, it's easier in some ways. 30 states, including Mississippi and a bunch of other red states, allow for the counting of mail ballots that come in shortly after the election, as long as they were mailed by the election. There are different ways to tell, postmarks are the most obvious way, but the USPS also scans incoming mail. Basically, the states say, look, if it was sent by election day, we think it should count. It's not the voter's fault that it didn't come in on time. A bunch of Republicans are asking the Supreme Court to strike down all 30 states' laws and prohibit the counting of any mail ballots that come in after election day. And that is a really, really, really big threat to the 2026 midterms, because we know that hundreds of thousands of these ballots get counted every election cycle. In 2024, it was more than 750,000 mail ballots came in right after election day and were still counted. So this ruling, if the Supreme Court takes up the invitation, would disenfranchise many, many, many people. It would also disproportionately hurt military voters and overseas voters whose ballots sometimes take a long time to cross the ocean and who are actually protected under a special federal statute that's designed to ensure that their ballots still count. I don't know where the Supreme Court's going to land on that, because the justices seemed really divided. I think that the Chief Justice and Barrett, again, the two key players in so many of these cases, they seemed a little skeptical because Congress has never actually passed any law that directly addresses late ballots. Republicans have proposed them. Congress has never enacted them. The idea, the sort of theory is that, well, we have an election day, right? It's the first Tuesday after the first Monday in November. And implicit in having one election day is that every single ballot has to come in by then. But as the chief pointed out, like, if that's true, then how are we allowed to have early voting? Because if we only have one election day, how are people allowed to cast their ballots for weeks or months before then? And I don't think that the court wants to strike down all early voting as well. So I think there's a chance the court could step back from the ledge there. But Calais, the Voting Rights Act case, is an even bigger threat, and it's one I'm extraordinarily pessimistic about. This is an effort to essentially kneecap what remains of the Voting Rights Act. The Supreme Court has already, destroyed many different provisions of it it by this point.
Right.
But this involves the ban on racial gerrymandering, the requirement that states protect the political power of racial minorities, that states do not carve Black and brown communities into oblivion through redistricting, that makes sure they can never actually elect their preferred representative. That's been on the books for decades. It's served our country very well. It has ensured that states like Alabama, Mississippi, Florida, Georgia are sending representatives of color to Congress, that the Black and brown communities in those states are able to band together and elect their preferred representatives. And in this case, the Supreme Court is very likely to just make all of that stop. I'm not sure exactly what the court will do. I don't know if it will strike down part of the statute, if it'll sort of reinterpret part of the statute, if it'll say that it's a violation of equal protection to protect Black voting rights. Whatever rationale the court decides, it's going to essentially declare open season on Black and brown communities in red states. And the best estimates show that it will allow Republicans to draw themselves something like 15 to 19 more seats in the House of Representatives by just shamelessly dividing up these minority communities, mostly in the South, and ensuring that their votes don't count. So that's going to be just an atomic bomb of a ruling. And it's probably too late to affect 2026, but it may well be the most important factor in the 2028 race for control of the House of Representatives.
And you've talked a lot about Chief Justice John Roberts, and he is clearly a very skilled politician. You know, he's very good at getting those serious articles written about him, about how he's so thoughtful and an institutionalist, and that he wants to preserve the court's independence. But when it comes to the issue of voting rights, this seems to be his passion project, to go after the Voting Rights Act. I believe it was 2013 with the Shelby County case that decimated a large part of the Voting Rights Act, when he was, of course, still Chief Justice. But long before, in his career, this has been an issue that he has paid extraordinary attention to, and clearly is not convinced, does not believe that this needs to exist. So you don't have that stopgap with voting rights. Do we have any sense from Amy Coney Barrett that she might be any more persuaded by the arguments to keep Article 2 in place?
I don't think that Barrett's in play here. I think that she is also really, really hostile to voting rights. And so are Thomas and Gorsuch and lately Kavanaugh as well. And I think, what's so disturbing to me about this case, other than their nonsensical claim that it's racist to protect Black voting rights, which is basically the argument being made by the plaintiffs, who are white voters who say that, these Black people shouldn't have so many voting rights. It's hurting us as white people. That's ridiculous. The outcome will be devastating. But what bothers me is that this is not a case where people are just going to the court asking for protection, right? Asking the court to make up some doctrine or reinterpret some constitutional provision to protect them. This is a case in which Congress did its job, right? Congress came in and legislated under the 14th Amendment a vast and broad protection for the voting rights of minorities, as it is constitutionally empowered to do. And the people's representatives, the people, who sent all of these representatives and senators to Congress, they are having their voices shut out by this case trying to dismantle the Voting Rights Act. They are seeing democracy eroded by unelected justices who don't have any democratic accountability themselves, right? This is a case in which the Supreme Court seems eager to prevent the people's representatives, prevent Congress from enacting legislation to address ills that Congress views as a serious problem still, right? Because Congress could repeal the Voting Rights Act anytime it wants. Congress could come in and rewrite Section 2, rewrite other parts of the law, take away the law altogether. But this is a case that asks the court to do that instead. And I think that is a dangerous step toward judicial supremacy and what some call juristocracy, sort of rule by judges, that seriously undermines our ability to think of ourselves as a democracy, because it's the court saying what the people want doesn't matter. All that matters is what 5 or 6 justices think the law should be.
Right. And of course, members of Congress have to take a tough vote that
Right.
they might be accountable for. Obviously, 9 Supreme Court justices never have to face the public in that way.
Exactly right. And it's an odd quirk of our system that I think has empowered the justices to push in a dangerous direction that is not supported by a majority of the country. I would file in the same category the campaign finance cases, right? Striking down laws that Congress enacted, right, pursuant to popular demand by the people to try to restrict the corrupting effects of money in politics. But the Supreme Court just strikes them down, and the Supreme Court never has to worry about losing their jobs because of it.
Right. And I can't help but think about the fact that the courts and the Supreme Court in particular have been such a focus for far-right groups for a long time. They identify the fact that, if you can capture enough of these, critical courts, and especially the Supreme Court itself, that is often easier than flipping a chamber of Congress. And when they're making such consequential decisions like this, from a purely political standpoint, that is a very wise strategy. But certainly, I don't think that this is what the founders intended with their separation of powers and how they expected that we would be carrying out their vision, 250 years in. Talk with us a little bit more about how we might try and restore some of this balance of power, because we see that the executive branch has expanded its power, especially the president himself. The court's power has expanded. And then we've seen that this Congress has really willingly given up so much power. How does this work, and how can we get back to more of a balance?
Yeah, I mean, I think that the answer here usually begins with Congress actually reasserting its role, right? And that would be especially helpful right now because much of the powers that Trump has been seizing are legislative powers. He's been taking away powers from Congress, powers of appropriation, right? How to spend money over independent agencies. Think like the Federal Reserve, who can sit on the Federal Reserve. He's trying to interfere with all this stuff that Congress established. And so I think if Congress were able to come in and pass more robust legislation, there would be some corrective. But the deeper question would still be, well, what do we do about the Supreme Court? And I think short of direct reforms, Democrats need to get really, really savvy about writing statutes that have sort of fallback. So for instance, and this is just one example, like Congress could pass a law that expands Obamacare and expands Medicaid and does all of these things that Democrats want to do, and then have a second section that says, by the way, if the Supreme Court strikes this down, then instead we're going to have Medicare for all, and just have this kind of backup option that kicks in.
Like a poison pill in every bill. Okay.
Yes. And there's nothing that prevents Congress from doing that. And it could have 10 backup options if it wanted. If we can't have Medicare for all, then we're going to have a public option or a single pay, like whatever, right? Congress could do that, but it hasn't because, these bills are obviously the result of like very careful compromise. But I think this should be part of the conversation when legislators are drafting their work, because anything Democrats pass, this is the reality, anything they pass stands a decent chance of being struck down by the Supreme Court. That's just the way that it works. The other thing I would say, and this is kind of tied in, is that Democrats need to put a time limit on judicial review for their statutes. So, the problem with the Supreme Court having total control over its own docket, one of the problems is that they can basically wait until Democrats lose control of Congress or one chamber of Congress and then strike down a law, right? They almost did that with Obamacare, right? The Obamacare decision came down in 2012. Democrats had lost control of the House after 2010. And so if the Supreme Court had struck down all of Obamacare, then there wouldn't have been anything for Congress to do because Republicans controlled the House. And they, even then, the Supreme Court really dismantled a lot of the Medicaid expansion in that law. Democrats didn't have the power to try to patch that hole. And so I think the Democrats need to start putting like a serious time limit on this stuff and saying that, you know, if this has not been reviewed by the Supreme Court and a decision hasn't come down within 12 months, the Supreme Court loses jurisdiction over the case, and that's the end of it, which is something that Congress, at least in theory, does have the power to do. Congress can decide what jurisdiction the Supreme Court has, what questions it can answer, what questions it cannot answer. And so this stuff, it's a little technical, right? I know it's kind of technocratic, but it's also low-hanging fruit and worth a try, because the Supreme Court has so many tricks that it can play to try to kind of prevent Democrats from passing enduring legislation. You know, I think if Congress passed Obamacare today, it wouldn't survive the Supreme Court. And so there are ways the Democrats can try to circumvent this and remind the Supreme Court that it needs to stay in its own lane. And then I think if Congress does try that and the Supreme Court doesn't listen, that's the point at which Democrats have to say, we've tried it. It didn't work. Now it's time to expand the court, because everything short of court expansion, it just doesn't work because the Supreme Court still holds too many cards.
Mark, before we let you go, what are some of the other key cases that you are keeping an eye on, and all of us should be as well?
So just a few. I mentioned the Federal Reserve. Trump is trying to fire Lisa Cook from the Federal Reserve's Board of Governors. A major case, in part because if Trump can fire Lisa Cook, he can probably fire anyone from the Federal Reserve and take total control over fiscal policy, including interest rates. We know he wants to cut them. That would allow him to do so. I don't think the Supreme Court's going to let him fire Lisa Cook, because the justices care about their 401ks and their grandkids' college tuition funds. But I do think that the court will, in another case, allow Trump to fire members of other agencies, including the Federal Trade Commission, which has been protected from presidential interference for more than 90 years now. The Supreme Court unanimously held 90 years ago that these kind of independent agencies could be shielded from the president. I think the Supreme Court's going to overturn that precedent and give Trump control over agencies that wield really extraordinary powers, and allow him to sort of seize those powers and exercise them very dangerously. I'll also just flag two gun cases. There's one case about whether drug users have a right to bear arms, and another case about whether states can generally bar the carrying of weapons on private property without the owner's express permission. This is the sort of steady expansion of the Second Amendment under the Supreme Court. I think each victory for gun rights imperils more gun safety laws. The court is certainly eyeing assault weapons bans for maybe next term. And so these two cases could show just how aggressively the Supreme Court is going to go after laws that try to protect Americans from gun violence in some relatively modest way that 6 justices might still say violates the Second Amendment.
Mark, thank you so much for being here. Really appreciate you breaking all this down for us.
Thanks so much for having me on.
And before we do let you go, let us know the best way that people can find your work.
You can find my work at slate.com. Mark Joseph Stern is the name. And you can also find me on Blue Sky at MJSDC.
Thank you again.
Thanks.